The next, the next thing we're going to address is it's a sort of we do 4 things a year collaboratively with CIBJO. And so this panel is one of those instances. Now, David Berdugo is unable to be here. He had a sudden urgency that required him to travel. And so what we're going to do is really a conversation between the 3 of us, Sarah Yude from JVC, who is also chair of CIBJO's Ethics Commission, and Jeremy Shepard, who is both the founder of Pearl Paradise, and I want to get the association name quite right, and he is the president of the Pearl Association of America. So we did a series together on intellectual property with CIBJO in various places around the world. And so this marks the start of a next inquiry. And this conversation really is, honest to God, the beginning of an inquiry. It is a conversation, and we may turn to you. So, without further ado. Yes, guys, it's me again. Okay. So, Sarah, you encouraged me to just start on a very basic level. Mm-hmm. So, on a very basic level, I'm going to ask you to tell us what is intellectual property.
Okay. Hi, everyone. I'm Sarah Yude. I'm the CEO and General Counsel of the Jewelers Vigilance Committee. JVC is a trade association focused on legal compliance in the jewelry industry. It's great to be here today, and I will answer this question. Intellectual property protects human creativity. So this has been around since before the United States was a country as a concept. It essentially protects authors and creatives and their creative output. So that includes the 3 basic parts of intellectual property are copyright, trademark, and patent. So copyright protects creative works of authorship, so music compositions, drawings, books, things like that. Trademark protects brand identity, so that's the name of your business. It is also your logo or maybe even a color that is associated with your business. So the Tiffany blue, the specific brown color of a UPS box is a trademark for UPS. And then patent, which protects scientific discoveries. Each of these different areas of the law have different lengths of time that they're protected for, depending on when it happened and what country you were in. But generally, copyright has the longest specific amount of time. A trademark can last indefinitely, so long as it's used in commerce. So the Coca-Cola mark will continue to belong to Coca-Cola forever. And patent has the shortest duration, and that is specifically intended to promote scientific discoveries. So patents are shorter so that other people, those inventions can fall into the public domain, and then other people can invent new things using previously discovered information.
Okay, so my next question is, and I realize I myself am on the low end, so I come straight out and say it. We have various ranges of understanding of what is AI and where AI hits a threshold of becoming, may I say, problematic, challenging. So I would ask both of you to effectively answer that question, and maybe, as Sarah coached me, generative AI.
So the basic function of generative AI is it's artificial intelligence that can create. So it is programming that can generate images or ideas or content. And this is different from previous versions of artificial intelligence because previously it was mostly used for things like processing power. So when we were discussing in our call, I was saying that my grandmother, Pauline Schlachter, was a secretary for New York Life Insurance Company. In 1975, she worked in the World Trade Center, and she was a secretary. But she did punch card programming of those giant room-sized computers. And so I like to joke that my Gammy was technically a programmer and was probably doing artificial intelligence before we even really conceptualized that. But the real sort of boom in the last few years has been in these, the artificial intelligence that is based on a large language model. So that means there is a ton of content that these AIs are trained on in order to learn how to create things. And that is all based on previously existing content that somebody somewhere created.
Okay, so then there is a problem of authorship. So Jeremy, I wonder if you could talk to us about the criticality of authorship. And we will tease you with an image in just a moment.
So thank you, Lisa. My name is Jeremy Shepard. I am the CEO and founder of Pearl Paradise and the president of the Pearl Association. And with large language models, we talk about authorship. Well, what large language models are doing is basically absorbing all of this information, all of these authors' works, and regurgitating it, not giving credit for the most part, sometimes combining it with other works, and really almost like creating a variant of the original work. For my case, I'm not an attorney, but I do have two digital assets that have a lot of content. Our association has a school. Pearl's is one. Well, Pearl knowledge, Pearl facts can't be owned, but the way we put the course together, the images, the stories, the way we educate, there is expertise and experience involved in that. And the way we present it is important. So we have it gated now, and so it can't be scraped the way Reddit or other sites may be scraped. But then on the other side, we've got a website called Pearl Guide, pearlguide.com, and it is a community discussion forum. Now, there isn't a single author there. There's about 10,000 authors there. And each one of those authors, or each one of those members, is the author of their own content, but it's a community forum. And today, a lot of the content, well, clearly it's been scraped, a lot of the content shows up in large language models, ChatGPT, Perplexity, Claude. And it shows up without attribution. It shows up combined. And it's concerning, On some levels, it's helpful. And the reason I say on some levels it's helpful is that the website is there to educate. So our intention, our goal, is to educate people about pearls, about the industry, develop a passion for pearls. And so on some levels, if we can get our friend ChatGPT to develop a passion for pearls, that could be great. But on the other side, if all of our content is absorbed on an industrial scale, then what's the point of an expert community forum in the first place?
So, Sarah, might you take this a step further? And we'd all like you to meet our friend if you turn to the screen.
So you might be wondering why there's a photo of a monkey on the screen. And I'm going to use this as an example to illustrate authorship. So in the United States Constitution, this is Article 1, Section 8, Congress gives Congress the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. This is the origin of copyright law and patent law in the United States. It comes straight from the Constitution, and as I mentioned, that actually derives from the Statute of Anne in 1710. So this concept has been around for a while, but authorship is the key factor here. This photo that you are seeing here was actually taken by this monkey. So there was a photographer who was doing wildlife photography, and he was in the jungle for multiple days, and the community of monkeys that he was visiting got used to him. He let them touch the equipment, he let them touch him, he let them, and essentially they learned, from him taking photography. They learned enough to understand how to use a camera, or maybe they just accidentally used a camera, it doesn't matter. But this is a monkey selfie. And the photographer whose camera this was tried to register this photograph for copyright protection. And the question was, can a monkey be an author of a photograph under copyright law? So actually, PETA sued the photographer saying, no, you didn't take this photo. The monkey took this photo, and we are suing on behalf of the monkey, and you're going to give all your proceeds to us. This was a long lawsuit. This is probably my favorite case of all time. It was in, I think, 2017, where they ultimately decided that under US copyright law, animals cannot be authors. And so what actually ended up happening was everybody appealed, and then PETA and the photographer settled out of court, and the photographer agreed that he would donate a certain percentage of his proceeds to a conservation effort in this specific habitat. So understanding who an author is incredibly important for the purposes of ownership of intellectual property. So unfortunately, this monkey, not an owner. That photographer is an owner. And really, an owner, an author, is the creator of the work. So that leads us to a really big question. When using AI, who's the author? Who's the owner? Whose work is being used? Who needs credit? Who needs payment? These, unfortunately, it's not always a monkey, although I think we'd all like to picture AI as like a bunch of monkeys typing in a room. That's not really what we're dealing with here. So the Copyright Office is the federal agency in the United States that sort of makes decisions about copyright law. It's actually part of the Library of Congress, and that's intentional because it's about creativity. And the Copyright Office has, over the last couple of years, has really been trying to figure out the question of, can AI be an author for the purposes of copyright law? And they have since determined that the answer is no, because there is no one, or even multiple humans behind creating work for AI. AI is creating based on all of this existing content. So it's creating based on Jeremy's content, and it's probably creating based on my content, and it's creating based on your content and everything you've ever written or published. And it's taking all of that data and putting it together in a new format. But under US law, it cannot be protected by copyright. So for example, if you're using ChatGPT to write advertising copy, great, but you don't actually own the copyright to that copy, and so you can't protect that using the current structure of intellectual property law.
Please.
So my question, and I don't know if I should direct this to you, but it's one that I've thought about and toyed with, is where's that line drawn? And I say that because if I am writing something and I ask a large language model to help me with an outline or edit my work, or I do a brainstorm session, well, in a way, what I'm creating is together with the large language model versus just saying, hey, prompt this, write a 1,000-word research paper so I can pass this class. So, and I know that a lot of the law is still undecided, but I think the line is starting to blur so much, and I don't think it's not understood completely by me. I don't know if it's really completely understood at all.
I don't think the law understands this yet, but I will say that I think copyright law does already have a large body of work about creativity and authorship. So if we take an example from the jewelry industry, whenever I'm explaining what jewelry designs could be eligible for copyright protection, one of the examples I use is a diamond halo ring. You're not gonna get a copyright protection for a diamond halo ring. Everybody's done it. It's been done in a zillion ways till Sunday, and the law doesn't necessarily see that as creativity. The threshold for authorship and creativity is quite high for copyright law purposes. You have to be able to show input and something new and original in order to get copyright protection. So I would say that although I don't think the body of law exists yet specifically applied to AI, we can look at historical precedent to say, okay, we know that the bar is pretty high, so we would expect that a court that is examining something to determine whether there's authorship or not is going to ask a lot of questions about what were the prompts, how much editing did you do afterwards, can we compare what the large language model put out with what you eventually published, things like that. I would guess that that would be what a court would look at if we were in a trial or in discovery.
So what if we approach this a different way? What about, let's take a designer, Melanie, for example.
Hi, Melanie.
You see one of her pieces, you know it's one of her pieces, and so her pieces can be copyright, right? Mm-hmm. Well, what about derivatives of that copyright? I'm not speaking to what can be copyrighted again, but I'm speaking to the protection of Melanie, for example, to take one of her pieces, maybe the Tasaki glove or the split pearls, and just taking a picture, uploading it to a large language model and prompt it, probably a little more detailed than this, but make a derivative of this piece, something that give me a design that you think might even be better.
So under copyright law, an owner of a copyright not only owns the rights to that particular piece, but they also own the rights to any derivative work that is made based on that original piece. It doesn't matter how much authorship there is in that derivative work. If it was derived from that original work, they own it. So my standard example for this is somebody writes a song and they make a recording of it. Great. The recording is a derivative work of that original composition. Whoever records that song has to get a license from the original author of the song. And let's say somebody hears that recording and then they're like, oh, my a cappella group would be so good at this. And they make an arrangement of that song for their a cappella group. That's so nice, but guess what? The original writer of that song owns that arrangement that you made, even though you put a lot of time into it because it is a derivative work. So the law does contemplate this, but I would say, I think everybody in this room knows that that's being violated over and over and over and over and over again in the current AI model.
Well, it has to be, because where do you draw the line again? Once again, I mean, derivative could be, so many designers, on some level, you could call their work derivative because they've taken inspiration from other designers. And
Well, a question for you guys. What is the line between inspiration and appropriation?
This is a question that doesn't have an answer, but I think it's so interesting to talk about that and to sort of like toe up to the line yourself and say like, okay, how do I feel? Like if I went to Claude and I was like, design me a Louis Vuitton handbag, or whatever, like it's gonna do it, and should Louis Vuitton sue me or Claude because I've done that? I don't know, because I'm not making anything, right? Like I'm not gonna take that to a cobbler in New York City and be like, make me a fake handbag. You can easily go to Canal Street and get a fake handbag if you really want one. But the question really is like, where do we draw that line? And does the benefit of the models outweigh the infringement? I don't think we can answer that question, and I think that's like part of why AI is such a hot button topic right now, is because everybody understands that there's a line being crossed somewhere, but nobody quite agrees on where the line is.
Well, also, don't you have kind of a double line in the sense that we have this problem of inspiration and appropriation without any machines, arguably, or with the machines that for us are quotidian and not in our consciousness extraordinary. Now we have this new force, if you will, and with it comes, as you're saying, the question of authorship. What other ramifications exist because of that? Because of the machine, if you will, perhaps being credited with authorship. What about, for example, Jeremy, you have talked about what gets put into, if you will, the marketplace visually that is created not by a human, and then what happens. So perhaps you could elaborate on that.
well, if we're talking about our earlier call, really AI is sort of blurring the line of legitimacy and illegitimacy. It's making illegitimate look legitimate even, and today on Instagram, for example, it's getting more and more difficult to know whether an image of a piece of jewelry, pearls, a model, people are AI generated or if they are real. And to me, this goes toward a different, subject, copyright, IP. It's outside of that, but it leads more toward consumer protection and disclosure. People they're getting fooled every day. They don't know it. Sometimes they do. And in fact, I think most people here have seen pieces on Instagram and other social media platforms, and you see them, and something doesn't quite sit right. Like, this is beautiful, but how did this company or designer, spend $50,000, $100,000 on a photo shoot with unicorns and castles? So really, to me, it's this line that's being blurred, and I think it's, from the association's perspective, just to sidestep here. The Pearl Association, we have several different levels of membership, and we've got a lot of members in the United States: pearl sellers, retailers, wholesalers, farmers, people that just work in the industry. And over the past few months, we've gotten a lot of new applications. Well, a lot, 3 to be specific, from companies that would pass our vetting and verification from any other standard just a couple of years ago. But we look at the websites and we see the product appears to be AI generated. We plugged the images into AI testing platforms, and they're not perfect, but they often can give you a percentage of, yes, this appears to be 85, 90% generated. We've seen entire websites that the stories are AI written, the images of the founders are AI written. There's an entire website about a family of pearl farmers in French Polynesia that's, now selling directly to the public. Everything is AI generated. And so again, it's really blurring the line between legitimacy and illegitimacy. And it's making things difficult for us as an association. We've had to create a completely new vetting process and a new set of standards. We now require telephone calls, video calls, until we get to the point where AI is so good we don't know if we're actually talking to a person or not. But we want to see the product. We want to know, are you actually a person professionally, or company professionally engaged in the pearl industry, or have you generated all of these images with AI, and are people going to be receiving plastic beads shipped from the other side of the world instead of actual pearls? And are you applying simply because you want us to give you that level of authority or that trust signal that our logo or that company's association with us would create? So it's a big topic right now within the Pearl Association.
Can you talk about some of the products that you're seeing?
Yeah.
Yeah, there is Pearl Guide, let's start with there. Pearl Guide is a website I started in 2004. And it's got about between 10 and 11,000 members. Not all of them are active, but there's a lot of active members. And all we do is talk about pearls and the pearl industry all day, every day. And most of the people there are not professionals. They're collectors and pearl lovers. And so we see basically all the gossip that happens. And images get shared of what gets received. And you can also see it on Reddit. You just search Reddit for Manea, M-A-N-E-A. That was the name of one of the AI-generated Tahitian pearl websites. And on the website, all these images were of these gorgeous Tahitian strands. And if you know much about pearls, you know, a Tahitian strand in a fine quality, something like this, you know, it'll set you back several $1,000s. And the story was that this family was finally deciding to go out of the farming business. They had pictures of the farmers and the farmers' sons, and they were all so good looking. You should have seen all the comments on Instagram from their ad. And there is now a big thread on Reddit, and there's actually a YouTube video that I found as well, at people sharing what they actually received. And the YouTube video showed a plastic string of beads. And the woman who put the YouTube video up is actually a pearl dealer. She thought, wow, these are really cheap, better than I can get at JCK or any show in the US. I'm gonna buy this because these pearl farmers are going out of business. And the thread on Reddit, if any of you look it up, shows an image of a strand of pearls in the buyer's hand, and I shared the image. I don't know if we're going to be able to pull it up or not. Of these tiny little rice-dyed freshwater pearls with a base metal clasp, not the 18-karat, 11-millimeter strand of Tahitian pearls. Granted, the buyer hadn't paid a reasonable price for those pearls, but it was several $100s. And the plastic beads are worthless, $1, maybe $2. The freshwaters in that quality, $10 maybe. Other than that, you know, I've heard stories and people have complained, and one other member of the Pearl Association, Matt Harris, ordered some earrings from another one, and they were beautiful earrings online, and he received something that could barely be described as pearls. So it's, yeah, it's beginning to become more and more of an issue, and I think consumers that do their research the background of the companies they're buying from, they're probably quite a bit more protected, but this is still 2026, and AI is so new. And AI is a generative learning platform. And so it will learn, how do I become more human? How do I become more persuasive? How do I become better able to manipulate? And so, yeah, things are changing quickly.
So, Sarah, I have a question. So I, too, went to this lady and I bought a Tahitian strand, and I am PO'd. And I don't just want to start a Reddit comment or whatever. I want to sue. Who am I suing? Or what am I? Can you sue AI?
Well, the New York Times and 15 other media publications are currently doing that. I think that was announced last week. They are currently suing OpenAI over copyright issues related to their own output. So yes, one can sue AI, but I don't think in this situation that's who you're targeting. In this situation, this is just a clear case of consumer fraud. So you're targeting that seller. And honestly, if somebody came to JVC with a case like this, the first thing I would tell them is to file a chargeback with their credit card company, because that's going to be the fastest way to potentially get recovery for your money. But I do think that it's a pretty clear case of fraud, and so it's not super difficult on the legal side from that standpoint. I think our larger legal questions are the fact that AI is currently completely unregulated in the United States, that regulation hasn't kept up with the pace of AI, and to be quite frank, you know, most members of Congress are not particularly well versed in technology and in AI specifically. And so the hope of, you know, having Congress regulate this in a way that is actually useful is maybe fairly low at the moment. I think that might change. I think there are some younger folks who are more well versed on the technology side who are trying to do this. And I'd be very curious to look at what states are going to do in the absence of action from Congress. I think that there are some states, like, you know, typically California is on the front lines of some of this work, and so I'd be very curious to follow what is going to happen there with, you know, with regulation. But I think in general, like, the tech boom of the last couple decades, you know, really led us as a society to value faster as better. And that this is playing into that value system, and the ultimate question for regulators to look at is, you know, how do we handle the fact that, like, the tech world is valuing even faster and faster. There's this, you know, billion-dollar AI tech bubble, maybe, who knows? And, you know, the question, I think, is AI helping that, or is it merely just contributing to the continued pressure of let's go faster, let's go better, let's do all of this?
Another question. So, conceptually, something is created by AI, but it's not realized. So, say, for example, the design for, oh, I don't know, a manipulatable necklace. And that design, that concept is purchased, and it doesn't work when it's built or when it is realized. Who or what is responsible there?
The point, I think, is that we actually need humans to create, because a human is going to make that necklace and then realize, oh no, this doesn't work the way it's supposed to. And so that is part of why we require humans in the process. And so what I would say is that, like, I don't want anybody to walk away from this panel thinking that AI is fundamentally bad, because I don't think it is. I don't think it is fundamentally good either. I think what matters is how you apply it and how you disclose and how you shape your own processes to make sure that there are backstops. So you can't just use AI to design something and then walk away from the process. Ultimately, if you're selling a product, you're going to be the one responsible for that product. And if that product doesn't work, you know, if somebody designed a ring on AI, and the shank is so thin that it's just going to break, and any basic jewelry designer would know, then that's a problem of the maker who didn't have the information when they were using the AI. And it's like, while it is the AI's mistake, it's fundamentally the person who makes that product. And so when we're talking about authorship and responsibility, that responsibility also falls back on the person who's actually making the thing.
So, in other words, just to clarify my understanding, you're suggesting that the responsibility for the not working could actually fall to the person who is realizing that which they purchased under the assumption that it would work.
Yes.
So we're going to flip it around now. And what we're interested in, well, we're interested in a ton of stuff, but at this moment, who is using AI in their business in this room?
I thought it would be really interesting to talk a little bit about how we're using AI. And so I will share that I think that I'm probably using it less than other people for a couple of reasons. Like we purchased an enterprise version of ChatGPT for JVC. And what I mean by that is we've gotten a specific license. We are paying ChatGPT so that the questions and queries that we put into ChatGPT are not used to train that larger model, so that it stays within JVC. And I would strongly encourage those of you who are using AI to do this, to license, to get a subversion, because it means that your content is not going to be used to train the larger model, and you retain the rights to your own things. I am using it occasionally to write outlines for things when I have to write a larger report. Sometimes I'll use it for ideas on outlines. We sometimes use an AI note taker to take notes during meetings. However, as a lawyer, there are some pretty large questions about privilege when you're using an AI note taker. And so there's a lot of conversations that I have during the day with my team or with the board of JVC where I'm not using that because I don't want to break our attorney-client confidentiality. So there's, I know that there's a lot of functionality with AI where it can go into your email and pull out things and tell you, like, oh, you need to do this. You said you were going to do this and you didn't do it. And those are all cool tools that I would love to use, but for privilege reasons, I absolutely cannot do that. So that's where I'm using it. I will also confess that last year I had to write a letter and I was really angry about the letter, and I wrote the letter that I wanted to write, and then I put it into AI and I said, make this much more kind. And the version of the letter that I sent was not exactly what ChatGPT did for me, but it helped me get it out. So I wrote my angry letter and then I sent a much kinder one.
Just a bit of a therapist.
It was really helpful.
Do you want
Jeremy?
to speak to this?
Wow. What do I use AI for? Well, I don't have an enterprise account with ChatGPT, but I've got Pro, I've got Perplexity, Manus, and Claude. And I use it for a lot of things. I use skills within Claude to manage PPC, pay-per-click advertising. It engages with AdWords, Facebook advertising. Not to write ads necessarily, but to control bids, schedule bids, etc. I love bouncing ideas off ChatGPT, and then I bounce those ideas off Claude. And so when we're writing scripts for videos, ideas for live streams, things like that, it's a great tool in that way. Anything contractually, and I hate to tell this to an attorney,
It's fine.
because I used to pay my attorney a lot of money to review documents, not so much anymore. Same thing with my CPA. And what you said, this letter, okay, I've had ChatGPT walk me down a couple of times, to tell me exactly why I shouldn't send this letter this way. This is what you're trying to represent. This is, it's sort of that whole never send an email when you're mad or angry. So yeah, it saved me quite a bit. In fact, I have an interesting story about this in a way. And this is just in the past week, we had a client who was using AI to request details on a fairly expensive strand of pearls. It's about $50,000, so it was a pretty significant strand of pearls. And she was writing with ChatGPT, and she was, very cautious about spending that kind of money on a piece of jewelry, clearly. And the AI was really protecting her. Let's put it that way, to say the least. And it kept pushing and kept digging and kept moving the goalposts to the point where we're sending 2 clasps to GIA to verify that the gold is 18 karat, even though it's stamped, and that the diamonds are real, even though the diamond tester says they are. It's kind of crazy. And it was frustrating in the beginning, but we've actually started to enjoy this process because we know it's the wave of the future. What people are doing now, especially with subjects that they don't really understand. AI makes you feel smart. It makes you feel competent. It gives them confidence. And in this same exact instance, AI can be very valuable because you know what we did in our responses? We talked to AI and said, what is everything this person's AI is going to question about this response, and how do we head it off before it happens? Mm-hmm. And so the entire business landscape, I think, is changing in this way.
I think it's important to note that, you know, I hate using the term the kids, but the kids are using AI really differently than I am, than we are. And in particular, I'm experiencing this with some, you know, other work that I do where I'm interfacing with communities of college students, and, you know, they are coming to us and saying, ChatGPT couldn't answer my question, so can you answer this question? And it's like, sure. But actually, you could have just skipped ChatGPT and come to me first, and then I would have answered your question. And oh my God, is it so terrifying to try to talk to a human? And the answer is sometimes yes. But I also think that, you know, we've already talked. You know, Gaetano mentioned COVID changing the way that we work. I think COVID changed the way we communicate as well, and so that for a lot of young folks, asking the computer is less terrifying than asking a person. And how do we change that? How do we make that where we can remind people that, you know, certainly ChatGPT knows a lot about jewelry law, but ChatGPT isn't necessarily going to be able to apply it exactly the way that you need it when you need a question answered, and so you should probably come to me. How do we continue to convince people that that's the route? I don't know the answer, but I think it's a big question.
In a way, aren't you talking about community and trust? Mm-hmm.
Absolutely.
Which takes us back to, if you will, Gaetano's opening comments. But, you know, who do you trust? And
trustability.
Pardon?
Trustability.
Yeah, well, that's Mark Hanna's word, trustability. For those of you that haven't had the pleasure of knowing Mark, he was the chief marketing officer of Richline, and always on the cutting edge of things that were happening, whether it was blockchain or climate issues, et cetera. And for him, the notion of trust was, if you will, sacred. And so he came up with this word that was, and I quote, as Jeremy said, trustability, which is kind of amusing English, but it's actually a really profound idea. Because, you know, who do you trust? And what do you trust? And with regard to AI, how attenuated is your trust? And who do you turn to verify the trust you are seeking to have in that thing? It sounds a little bit solipsistic, but it really is, the way it goes.
I think it's a good reminder that, you know, I think you should have a healthy dose of skepticism when you're using AI. As I mentioned earlier, I want to emphasize again that if you're just using the free version of ChatGPT, you are giving ChatGPT every single input that you're putting in. Any document you upload, any query you ask, like, you are helping train it. And when the product is free, you're the product. So keep that in mind when you're using AI. If it's, if you want to make sure that your work isn't being co-opted, you have to be really careful about how you use it. But I do think that there are all of these benefits, as as Jeremy has shared, all the work that he's using AI to help with, advertising and, getting rid of lawyers, which I know everybody else wants to do, and but even like that the work itself is fundamentally changing. So there is an AI product called GC AI that is literally created for general counsels at companies, and it effectively allows you to do some of the contract work that a low-level junior attorney would do. And a question that we're talking about in the legal profession is, that's great that we can automate some of this stuff, but also that means that once that, if we're not training those junior attorneys on this work, we're not going to have mid-career attorneys, right? They're not going to have gotten the foundational legal work to then do higher level legal work if we're just completely leaving them out. And so how do we make sure that the legal system is still working the way it's supposed to, so that we're going to have lawyers with experience when we need lawyers with experience? I think that the question of the notion of the work itself is changing, and so how do we ensure, again, that authorship is valued, that people are valued, that processes make sense, and that the AI output itself is actually useful?
To me, there's an inherent paradox, which is, and we talked about this in our calls, but how do you, on the one hand, what you need to, one of the things we all, I guess, need to be vigilant about is, not to be, in effect, seduced by an easy solution when we still have to protect creativity, individuality, humanity. So it's a delicate balance, and I certainly don't have any answers. I'm not sure either of my learned colleagues do, but it also takes us back to something that Gaetano brought up in his opening remarks, which is the 17 SDGs, and the things that when you go, for example, to a conference such as this, many people ascribe to the 17 SDGs, maybe selecting those that they feel most able to target. But one of them is, a living wage. And there are other issues that are brought up. They kind of create a conundrum of AI going forward, and then also the personal engagement. So if there are any questions, Everett.
I have a question and a comment. What about human rights with AI? I really appreciate Gaetano's comment about protecting the consumer. I think human rights are critical in this particular stage. That's just my humble opinion. And I'm not a smart guy, I'm a stupid guy.
You're not a stupid guy if you are putting human rights first. So it's a huge question that I can't even begin to tackle. But I agree that it should be prominent in our thinking about AI.
Michael?
Sarah, thank you for that, your invaluable contribution. And while you're dispensing some free legal advice.
It's never legal advice, it's just opinion.
My question is for the free legal advice then. That for anyone, let's say, in the room who later today is going to create something from their heart, from their mind, what's your quick how-to guide for how to immediately protect your intellectual property?
So
Is
good
it by
news.
documenting somehow visually, creating a paper trail of some sort?
The great news is that as soon as you draw or create in CAD or anything like that, you do make a new jewelry design, you already own copyright rights in that design. The copyright law says that you can't, once you fix something in a tangible medium, you own the rights. So that means you record it, or you write it down, or you draw it out. For ballet choreography, usually it's like you notate the choreography or you take a video, something that once you have created that, you own the copyright already. The question is whether you can get a registered copyright. And so that's when you have to go to the Copyright Office and file an application. And it is getting more and more difficult to get copyright registration as people create large volumes of jewelry designs using computer-aided design or other ways, but you already have rights as an author as soon as you write it down or draw something or take a photo or anything like that.
I think right up here you had one. Yeah. No. Yeah.
Okay. My favorite quote goes, "To tell the truth, there's no fraud or deceit in the world that yields greater gain and profit than that of counterfeiting gems," unquote. You probably know that was written in the year 77 AD by the Roman historian Pliny. It is not any better today. In fact, it's far worse, because it was one thing in the olden days to get even with those wealthy people who were subjugating you in every way they could. But that's not the case today. The number of people who want to have a beautiful piece of jewelry to wear is higher than ever before in history. But it's at every level of the economy. There are things for every level of the economy, but they have to be accurately and properly disclosed and truthfully disclosed, and no one is, number one, educating the buyers about what they should be verifying once they buy, because if you're buying online and it's coming from God only knows where, or you're buying from a chain store or an independent jeweler who is so nice, all those unbelievable deals on 47th Street. I mean, the people I meet who are so proud of this phenomenal sapphire ring they got for a fraction of the cost they could find it anywhere, but it was synthetic, except it wasn't, the word synthetic was not on the sales receipt. But they have the sales receipt, so they think they have, why check? They put it, then this is a sapphire, on the sales receipt. And the real cons have figured out how to take advantage of the consumer. I think we need to educate consumers as to where and how they can confirm what they have purchased. Because only by doing that do they have a reason to put their trust in the seller, or the way to find out that seller is not honest and reliable. And nobody's doing it. The jewelry industry today is not offering education to any of its customers. I can remember 25 years ago, retail jewelry store chains would bring me in first to train their buyers.
Do you have a question?
Sorry. But the point is, when are we as an industry, particularly the jewelry industry, going to start encouraging the retailer to do more consumer programs to help consumers understand what is in the marketplace and how to know that what they're getting from me is accurate? And working with people like the AGA, Accredited Gemologists Association, and gemologist appraisers versus the appraiser who simply wants to see your sales receipt and then they write the appraisal based on what the value is shown. I mean, it's unbelievable what's going on today, but we can fix it if somebody focuses on educating the public as well as people selling.
Full disclosure, the person who's speaking is Antoinette Matlins. And she is a very fervent advocate and noted authority in the field, particularly of colored stones. I think what's happened is she's asked an interesting question at the end of the commentary, because it's three-part. One is, or statement, the criticality of education. And if you are educating the consumer, that means you have people who can educate the consumer, which means that whoever is educating the consumer has been educated in another fashion. Therefore, we can never stop learning because we must constantly teach in order to learn. The other question is, to come back to this panel, how does that relate? I'm not saying it doesn't, but how does that question relate to AI and this being the source of knowledge and purveyor of knowledge? And what role does it have, and who, as Jeremy has addressed somewhat with regard to the Pearl Association, who actually, where is the repository of that expertise? And if Sarah or Jeremy have a closing remark, I'm going to leave it to them. But otherwise, I think that's kind of an interesting place to stop, because it's also going to be an interesting place to start. So, thank you, everybody.